The Julian Assange saga has taken a number of dramatic twists and turns over the past 2 years, all of which have ignited a great deal of global debate. In the midst of the latest controversy, the British authorities cited the little-used Diplomatic and Consular Premises Act of 1987 as justification for their threat to enter the Ecuadorian embassy by force. But what exactly does this obscure piece of legislation mean, and what are its implications? Our correspondent in London, Farzana Fiaz, takes a look.
The impasse faced by the United Kingdom and Ecuador has the hallmarks of a potential diplomatic incident. If the British authorities revoke Ecuador's immunity and raid its embassy, it would be considered by them to be a massive breach of international law. So how did British officials arrive at this point? The answer lies in a little-used piece of legislation. Former British government lawyer Carl Gardner explains.
The Diplomatic and Consular Premises Act 1987 is a piece of legislation that gives British ministers a power effectively to de-recognise the diplomatic status of embassies in London, either because they're being misused, perhaps in a way that breaches the Vienna Convention on diplomatic relations, or for some other practical reasons, like for instance that the buildings themselves become unsafe. This legislation has very rarely been used. It was passed in extreme circumstances after a situation in the Libyan People's Bureau in London, where a British policewoman was shot and murdered from the windows of that embassy.
The British diplomatic predicament is not unusual. There have been other cases of diplomatic asylum that have been similarly contentious.
And it's been used once, as far as I know, in the late 1980s when the Cambodian embassy was abandoned by Cambodia's diplomats and squatters moved in. And effectively the UK government used this legislation so as to protect the embassy and regularise the position.
The matter is further muddied by political considerations. Encroaching on diplomatic immunity might set a dangerous precedent by encouraging other governments to justify wanting to forcibly remove dissidents from their own foreign embassies.
When the British invoked the 1987 Act in a letter to the Ecuadorians, it was a sign of the unique nature of the Assange asylum case. That the British sought to distance itself from it shortly after, however, shows the incendiary potential it has. Either way, this case is likely to stump legal and political minds for some time to come. Farzana Fiaz, CCTV, London.